Welcome to the Supreme Court of the United Kingdom. Today we're hearing an appeal in the case of Henderson and Dorset Healthcare University NHS Foundation Trust. In view of the coronavirus crisis, the members of the court and counsel are all sitting in a variety of different locations linked by video conferencing software. In a moment, I'll introduce the members of the court who are sitting with me. Then I will hand over to counsel to begin their submissions. The other members of the court are first Lord Hodge.
Good morning.
Lady Black.
Good morning.
Lord Lloyd Jones.
Morning.
Lady Arden.
Good morning.
Lord Kitchen.
Good morning.
And Lord Hamblin. I'll invite counsel for the appellant, Ms. Bowen, Queen's Counsel, now to introduce counsel and prepare and begin his submissions.
Good morning, my lord. Are you receiving me?
Yes, we can hear you, thank you.
Good morning, may it please you. I appear along with virtually Katie Scott and Mr. Fairgrieve, who is in France, and acting for the appellant, Ecila Henderson, a protected party represented by the official solicitor. The learned friend, Mr. Angus Moon, QC, leading Judith Ayling, Cecily White, and Mr. James Goodcamp, act for the Dorset Healthcare University NHS Trust. This is my appeal from a decision of the Court of Appeal rejecting our arguments that the illegality defence did not apply to her tort claim. And what I'm going to do, there are a few housekeeping errors which you have in a speaking note, which I'm not going to go into. And I'm just going to go just fairly briefly through what we see as some of the relevant facts. If you go to electronic bundle page 50, you'll see the statement of facts and issues. And again, I won't go through that. I anticipate you possibly had a chance of looking at some, if not all of it. Paragraphs 1 to 5, from about the age of 24, Ecila started developing mental health problems. That's around about 1995. She's born in 1971. She's now 48 years old. She had various admissions into psychiatric hospital from 2003, a long 2-year inpatient period under Section 3 of the Mental Health Act. That's 0608. June 2008, she's given something called Section 17 leave. So she's still under the care of the NHS, but allowed to then live effectively with supervision in the community. That order was made under Section 17A on the 14th of January 2009. Crucially for us, this is all common ground, the care plan, because of what we say were very significant issues relating to risk, was that there should be an instant threshold for recall if and when she relapsed. She's paranoid schizophrenic and really quite a profound psychiatric problem. Paragraphs 6 to 14, which you can just browse through, set out the circumstances of the return of her illness when she was in supported accommodation, various acts and omissions of the respondent, and the event, of course, which is at the centre of this tragedy, which is matricide, the murder of her own mother. Paragraphs 25 to 27 of the document show precisely how psychotic she was upon arrest. And there's a lot of psychiatric evidence that I'm not going to go into in any detail. It's all there in your papers, and I'll refer to it as I go. But prior to the killing, you can see that everybody was agreed she was acutely psychotic, vacant, muttering to herself, drinking excessively, including from the toilet, deemed unfit for interview after the arrest. And then we say pretty significantly, because it's a window on what was going on before, 2 days later, and for several weeks after, when then in a high security hospital, very psychotic, pacing up and down, responding to hallucinations, hearing friends' voices, stabbing gestures, saying that it was her mother's head that she was stabbing again. No understanding at all of the gravity of her actions. Reincarnation delusions that not only was her mother not dead, she was alive. She also had died, I think, 10 years earlier. There's a lot of detail, which I don't think we need to go into. At the center of our analysis, of course, is that this is a case, unlike many that you will have seen from the bundle in the Commonwealth particularly. The duty of care is common ground. So there is an accepted cause of action, a complete cause of action. No issue at all about novice actors. So no intervening cause argument. All the material about jobbling and that argument in the Gray case doesn't come in here. So we got foreseeability, and we have, on my understanding, also causation. I won't turn them up, but you see the pleading at Electric Bundle, page 260, and the defence then at 273. Just a very quick word on that. Because by then judgment had been entered, you see that that's the next reference on the speaking note, 8th of May 2014, EB 257. No criticism here. Understandably, the defendants who were then accepting that they were accepting liability, they wanted to keep the costs down. They didn't want the case to be pleaded out properly. So the actual breaches have never really, they're in correspondence, but they're not, you won't find them in the pleadings. The respondent relevantly reserved its position on the recoverability of the heads of loss and stated that they would take a public policy point in relation to the loss of liberty argument. Now, could I just say there quickly, just so for your note, we have I'm averse normally to taking pleading points, particularly in a case of this complexity. We do sort of hint that the illegality defence only goes formally to one head, but I'm not. I mean, you've got my submissions in that on paper, and I'm not going to make a big song and a dance about that. The findings of the independent report are summarised, we say briefly, at let me just have a quick look at that. EB Electronic Bundle 57. And that's paragraph 36. And in a nutshell, safety net on relapse failed to operate. It was always planned in this case, because of what I'm going to describe in a moment, that there was danger sort of up in their hills if she wasn't cared for, as and when things started deteriorating, as of course happened. And the word instant is really rather important. I mean, from that we get really how serious potentially it would be if she did begin to relapse. Now they accept, the learned friend and his clients accept entirely that what they call an untoward incident was foreseeable. Now we say politely that is really effectively simply code for saying that if she relapsed in the community, serious violence was, to put it at its lowest, a serious and real possibility. So bottom of page 2 of the note, summing it all up, the respondents were negligent in failing to return her to hospital on the basis of her manifest psychotic state. That's the same paragraph 36. Her condition was a danger to others, and plainly the tragic consequences that followed, not only for the innocent life of her mother that was taken, but also and I don't want to overplay this, the destruction effectively of, when she got better, having to live with the quite appalling reality that she had killed her mother. So the stakes in this high, I mean, I'll go on in due course about incoherence and what you've got on both sides of the balance. On her side is a very real and very profound loss, the loss of her mother and the loss really of her freedom and the loss of effectively any sort of normal or independent life that she might have enjoyed had she received what she should have received from the defendants, which was, of course, competent medical care. None of this would have happened, we say. Don't want to be too harsh, but this would simply not have happened had there been due care, due diligence, all of the ordinary, completely familiar tenets of tort law kick in. And the question really that we're all wrestling with is, well, is it really proportionate? Patel will come on to in due course. That all that should be lost simply because of the existence of some technical mens rea and an argument about Section 2 of the Homicide Act. So, again, I just sort of put this down as a flag. You can see the penultimate bullet point there on my speaking note, risk of violence. I've made that point. Annex 1, don't turn it up, but it's there for you to have a bit more information on page 111. Now, as a word on that, why that exists. That document is not, we were very surprised about this. That document is not common ground. There may or may not have been a bit of a battle about getting it to the bundle, but we put it in anyway, because we see it as highly significant. The respondents have been very keen to keep us strictly within the confines of the SFI on the basis that it's all agreed and we can't go beyond it. Well, we have absolutely no hesitation in saying to you that insofar as you want any further information about the circumstances of this, the level of risk, you can see it at Annex 1. Technically, it's not an agreed document, but it's all accurate. It's all there. All it is a distillation of their own document, their own SUI report, the Serious Untoward Incident Report. There is the 200-page document itself, which we wanted in the bundle, but again, there was resistance to that. So you don't have that. It may well be ultimately that it doesn't matter because the core of it is that we have a complete tort claim which has been accepted. There may or may not, if this had ever gone to a trial, it may, who knows what's in the future, be arguments about, there could in theory, I should say, been arguments about foreseeability. There are all sorts of things that could have gone into this case had they not admitted a duty of care. And we'll see that from some of the Commonwealth cases. But we're not there in that country. We are only simply talking about the illegality defence. So now turning to the law, I intend to cover or try to cover 4 areas. Gray, Clunis, Patel issue. That is the argument about whether or not the test which Lord Hoffman developed from Lord Justice Beldam in the Clunis case, whether that is truly a unitary or, to use Mr. Justice Jay's language, a monist test. We say on any view that monist test is not compatible with Patel, and we will ask you to consider departing from either all of or those elements of Gray which cannot live with Patel. We say you should overrule Clunis. We do have an alternative submission, which is that you can distinguish the Gray case on the basis that the ratio is limited to those with personal responsibility. And as Mr. Justice Foskett found so clearly, I won't go to it unless I pick it up in my speaking note, but you will probably have seen it by now, that he was of absolutely no doubt that this was a case where she had no significant responsibility. It was all a tragedy. He wasn't going to go into the whys and wherefores of why it happened, but he wasn't going to punish her, and therefore he didn't use the hybrid order under Section 45A of the Mental Health Act. So that's issue 1, or sorry, my area 1, my question 1, and that covers issue 1 and 2 on the SFI. Which
can I just interrupt you for a moment, Mr. Byrne? Are you going to come back to the point you just made that if punishment were intended, an order would be made under Section 45A?
We will. We haven't gone into that in enormous detail in the document. We of course will react to any questions that you've got. But what we say there is, I mean, I'll get into this as I go. But I think in a nutshell, if the hybrid order, this is all explained, I think, at paragraphs 8 to about 8 and 9, I think, in Lord Phillips's decision or judgment rather in the Gray case, that 45A is the relevant disposal insofar as some form of penal message, a prison sentence is necessary. That's the change in the law that enabled the courts to be able not to have a clear choice between either a hospital order and or a prison sentence. So we say the fact that 45A was not used and that the treatment order and the rehabilitation inherent within Section 37 hospital order tells you really almost all you need to know about what Mr. Justice Foskett was thinking. So, I mean, I can take you to the legislation, but we don't see that as absolutely, I mean, it's key to the case on one level, but it's not key to the case in terms of the analysis that we have, the way we structured it in the note. So that then takes me, my lords, my lady, to the second issue, which covers issue 3 in the SFI. That's the threshold and turpitude issue. And there we say that despite the, of course, appalling, unspeakable nature of the physical nature of the crime, because no significant personal responsibility attached to this case, we say that really there is no sufficient turpitude to even get in to the doctrine and therefore the application of the Patel test, because the respondent's tort was the effective cause of the killing and of course then the effective cause of the losses. Then the third issue that I will address is issue 4 and 5 in the electronic bundle, page 58 to 59, and that's what we've called the Patel issue. And there we say you should first of all consider remitting the issue, as evidence on our case will be required. Unlike the Stoffel and Gradona case, there has been no trial. If you want to hear submissions on that basis, then of course we can do that. And you, in any event, have quite a lot of that on paper. It may well be that I don't have time to go into that in the sort of detail that I'd like to, but I'll try. The fourth issue then is issue 6 on the SFI, again, EB 859, or what we've called the alternative test issue. If the Patel test and the Gray test are not to be applied, then what test should be applied? And then again, the same question, is that a remittal issue? Or is that something that has to be dealt with by the first instance judge, or can it be dealt with by the Supreme Court? And our answer to that is really very brief. Just for your notes, you'll find it on page 74 of the speaker. It's taking the Sarah Green line, that's EB 724. Sarah Green EB 2935, and the Master of the Rolls, Sir Anthony Clark, of paragraph 49 of Gray, where the short point they make is, why is it needed? Why do we need ex turpi causa or the illegality doctrine in this type of case? The ordinary rules of tort suffice. So that brings me to the first question, the Gray, Clunas, Patel issue. And we say that this is really the core issues on this are responsibility and coherence in the civil law. Those two concepts will run through everything that we've already got on paper and everything that I'm going to say. Clunas and Gray cannot accommodate the structure and the flexibility that is inherent within Patel. Underlying both Gray and the Patel approach to the illegality doctrine is this absolutely fundamental point that comes from Canada. I think eventually it's anchored to Hall and Herbert. Law must be coherent and not self-defeating. Those are the key words. They're the two broad policy or discernible policy reasons which justify the doctrine as a get out of jail card, effectively in this case, for the defendants. And could I ask you to just turn that up? I suspect you'll be very familiar with a lot of this material. So if you don't want me to go there, please tell me. But 863 is Lord Toulson in Patel. And it's paragraph 99. Looking behind the maxims, there are two broad discernible policy reasons for the common law doctrine of illegality as a defense to a civil claim. One is that a person should not be allowed to profit from his own wrongdoing. The other linked consideration is that the law should be coherent and not self-defeating, condoning illegality by giving with the left hand what it takes with the right. And subject, obviously, to what happens in the next 3 hours and what Mr. Moon says, we say there's no real contest about profit here. There's no question of her profiting in any way. The profit or any compensation that she gets is compensation for recognizable losses. So it's not that kind of case. It's really all about incoherence. Notion of coherence and consistency, I then go on to from paragraph 8 of the note. Now, there are lots of sometimes phrases which are used which are in danger of sometimes being a little empty of content. Civil and criminal law should march together. Coherence and consistency are important features of a legal system. They're amorphous notions and they require clarification to ensure that they are applied correctly. Now, we say that this is really a classic case where you've got to really drill down very hard into what consistency and coherence means in a case here where you've got the interface of tort and crime, an area, incidentally, on which it appears not very much work academically and in research terms has been done. And the court are fortunate enough that a leading academic who has been working in this area for some years, who you, as a panel, may or may not be familiar with, an associate professor, Dr. Matt Dyson at Corpus Christi College from Oxford University. He has produced what we think is an excellent paper called Coherence and Illegal Claims. That's from a forthcoming book that he's been working on for about 4 years. You see it, don't turn it up at the moment, but you find it, and we recommend the entire document to you for careful and close reading at electronic bundle 3717, particularly the section on Gray, Clunas and Henderson at 3733 onwards, where he deals specifically with coherence and Henderson. And I'll just read the conclusion. You'll see it at 3743. So if we just pull it up for that purpose. Conclusion. And you see it 3743. Henderson it's in the note. I can't see it immediately on my screen, but Henderson is a classic case where a fuller understanding of what was meant to be coherent would assist in coming to the right outcome. That the tort law claim is not barred. Here, the key factor is that criminal law is not engaging in a prohibition, the force of which would require tort law to prevent related claims, where the individual concerned has little or no personal responsibility. And of course, we say was crucially not. I think they lost me. Did you lose me then?
We can hear you, but we can't see you.
Yeah, I didn't touch anything. Can you see me now?
I'm afraid not. We have better waiting numbers until we've got visual restored.
Can you hear me, my lord?
Yes, we can hear you.
Can you see me? May not be a good thing. you hear me, my lord?
Yes.
I think I may be coming back.
Yes, we see you now.
This is a completely regular laptop. I am not touching anything, so I apologize profoundly for having disappeared. Where was I? I was emphasising, I think, the lack of personal responsibility and the absence of punishment. So
something, can I just intervene? Something else I don't know if you're going to expand on is how this question of responsibility should be approached. Obviously, the criminal law has tests, and if there is no responsibility, then you are acquitted on the ground of insanity. But if there is responsibility, in this case, it's a case of diminished responsibility. So some responsibility has to be present in order for the court to proceed on that basis. I'm not sure if you're suggesting that the civil law should have some different approach to the question of responsibility, and if so, what it is.
I think Mr. Moon might be having some difficulty hearing us.
My lord, sorry, I found it very difficult to hear what your lordship said.
I'll repeat it. I don't want to take Mr. Bowen out of order if he's going to come back.
It's still very difficult. I'm very sorry. You're speaking
from my end, my lord. Can I just say, you're coming and going, and then sounding a little like a Dalek. But that's not what offence meant.
We're getting a strong echo coming through as you speak for some reason.
Turn the volume down, perhaps. You come and do that. I'm very reluctant to touch it.
Perhaps if you turn off your own, yes, you're muted. So, can you hear me? Yes. Okay. No. Do you want to continue meantime? And I can ask my question once we've got the problem sorted.
No, I heard your question. I did hear your question.
Well, I'll try again then to repeat it for Mr. Moon. I was asking Mr. Bowen if he was going to address us on how the court should approach the question of responsibility, as he's relying on Professor Dyson's approach that here there is little or no personal responsibility. And I was pointing out that the criminal law has an established approach, and a conviction on the basis of diminished responsibility implies that there is a significant degree of personal responsibility.
I think the problem, my lord, webcam's got disconnected again. I haven't touched it. Can you hear me, my lord?
Yes, I can hear you.
It may be that you might have to face not seeing me some of the time because it's coming and going. I think half the problem may be when you lean back, the sound quality deteriorates very, very significantly.
Yes, it doesn't explain why your video link cuts out.
Why my video link?
I wonder if we should. I don't want to end this meeting in terms of the software, but shall we?
Well, I'm back now.
Okay. Well, let's carry on.
I mean, I'll try and race through it as quickly as I can because I can see that we're going to have a lot of a lot of issues. In terms of the significant responsibility, we have thought about that. We do have what we perceive are acceptable answers, having anticipated that question. And if I could just rattle through that now, just very quickly. I mean, this was coming in a bit later into my address.
Well, we can wait for you to get to it.
Can I come back to that? I'm
certainly
aware of that. And we have what we say is an answer. So just going back to Professor Dr. Dyson, he points out in his analysis that the criminal law outcome does not prevent liability in the law of negligence, given that key point, which I'm going to go back to time and time again, personal responsibility. To somebody who is on the edge of McNaughton insanity, but isn't quite there. The psychiatrist can't say, you've got all our stuff about outmoded, discredited. The only reason McNaughton, my lords, my ladies, has survived is because hardly ever anybody uses it. 30 people a year. The Law Commission, you'll be familiar with the Law Commission material. They've looked at this issue for what, 10 years plus. And the only reason that they did not move on insanity was because there was no practical, realistic problem. All of the problems existed in relation to fitness to plead and other areas. So McNaughton, a Victorian rule of extreme hard-edged, we say harshness, that would accept, so a classic example from McNaughton, somebody who throws a baby into a fire but thinks the baby is a log, has no idea about the nature and quality of his or her act, doesn't know what they were doing is wrong. You get other examples, man cuts wife's throat, thinks it's a cake. I mean, that's horrendous, but could not be clearer. In a case like this, we have a woman who is desperately trying to fight the psychotic urges and the hallucinations and the commands within her head, desperately ill, not recalled. And the only reason that she has lost her tort claim is because the psychiatrists weren't able to say that when she stabbed her mother 22 times, she didn't actually realize that it was her mother. So it's not a cake case. It's not a baby in a log case. It's a case where you've got somebody with no capacity, hence no responsibility, but the law from Clunas and Gray is so bright line and clear cut that she is chopped out with all of the implications that I've already set out. I'll come on to your question as soon as I possibly can, or to answer it. So no risk of undermining, because I keep going back to that all the time, undermining and incoherence. No object or policy of the criminal law is being profoundly or even significantly affected because there's no punishment. There's no left and right hand problem here because it's not a punitive situation. And there is no serious suggestion that, we say with respect, can be no serious suggestion that compensation is going to undermine the integrity of the law in the mind of either the sensible judge or the classic sensible person on the London Underground, Clapham omnibus, whatever. So that keys into one of Mr. Moon's points, which is the importance of the declaratory purpose of the law, that a purpose of the criminal law is to reinforce prohibitions. And we're all encouraged to not break the law. I think this is something that came into the Stoffel and Gradona case when my Lord Reed was having an interchange with Mr. Warnock, where I think you described the deterrence point as absurd. But we say the deterrence point, it's around about paragraph 80 from memory in our written document. It is completely ridiculous. I don't hold back on this, to suggest that just before she plunged the knife into her mother, she thought, oh, whoops, I better not do this because I'm going to lose my claim in negligence against the NHS. I mean, it's just an absurd point to make. And to be fair to Mr. Moon, I'm not even sure that he makes it, but just in case he does, that's what we say. So paragraph 12 of the note, in relation to the need for coherence and avoiding incoherence is allowing this claim to proceed. That is the balanced, sensible thing to do, not to pull the rug from under the case. That's effectively another way of putting the threshold point, which I'll come to in due course. So paragraph 13, I mean, in many ways, these are all different ways of saying the same thing, for which I apologize. But if you follow our route, you're denying that, if you don't follow our route, the denial of the tort claim by means of illegality would constitute a punishment meted out by the civil law when the criminal law had actually declined to punish. So that in itself is something that makes no sense. And then I think paragraph 14, I mean, I've already covered that. No section 45A, only sympathy from the judge about the appalling event that has overtaken the lives of so many people. Top of page 6, different functions of tort and crime. Criminal law is there to punish. It is there to provide sanctions for behavior which the state has decided are necessary rules and behavior that is or is against the general interest. So it's what the academics call making sure that the society generally has normative compliance. Criminal law punishes and uses sanctions for those who are responsible. So that's keying in to my Lord's question. But not only responsible, but also culpable because of the behavior in transgressing a particular rule. Now, we know from what happened in this case that criminal law remedies are flexible. They are flexible enough to recognize that even when constituent elements of a crime are satisfied, so Mr. Moon's point, section 2, or the Clunas and Gray points, you have what I will call residual mens rea. It's still possible to have residual mens rea and no significant responsibility, and therefore no punishment follows from the criminal system. So criminal courts punish people who have responsibility, and they do not punish people who do not have responsibility. You can cut out 20 and 21, put a line through that. I think that's just repetition, unless I've removed it in your, that may not. The next sentence, or the next paragraph, consequently, that's my paragraph 22, consequently, if a crime is caused by a tort, as here, the ordinary principles of duty breach should kick in, and that's coherent. I made that point. So then we come to the theories of criminal responsibility. Fully looked at in Appendix A. Could I ask you to turn that up? 3618 of the bundle. And this is work from the Annex A to the Law Commission's document. Yeah, Katie, was that? Right, 3618. Oh, sorry, answer my own question. 2013. So this is, here you see, if you go up to the top of 3618, a full explanation of the various theories of criminal responsibility is in the bundle. And it was part of the discussion paper on insanity and autism. Oh, sorry, automatism, forgive me. And I want to take you to just to 4 sections quickly. The first one, A1, criminal law is generally thought to be founded on the principle that a person must have been responsible for his or her actions in order to be held culpable and to be punished. So got to be responsible to be culpable. The second it would be unfair for those whose serious disorders cause them to lack criminal responsibility at the time of an alleged offence to be at risk of the same outcome, a criminal conviction, as people without that serious condition. As Lord Bingham or Lord Justice Bingham, when he was the LCJ, said in the Court of Appeal, it would be offensive to visit the full rigour of the law on those who are not mentally responsible. And that, we say, is bang on the money in relation to the facts of this case. And then A5, our principal conclusion is that people should not be held criminally responsible for their conduct if they lack the capacity to conform their behaviour to meet the demands imposed by the criminal law regulating that conduct. This lack of capacity might consist in an inability to think rationally or in an inability to control one's actions, all of which, of course, applied to Ecila Henderson.
It cannot if she was convicted of a criminal offence.
I'm sorry?
See how this court can proceed on the basis that she lacked criminal capacity, because if that were the position, she could not have been convicted, as she was, of a criminal offence.
We accept, we don't seek to challenge the conviction in any way. The
only reason why the law can, if she committed any offence other than killing her mother, if, for example, she had stabbed her and seriously wounded her, she would simply have been convicted of GBH.
And given a hospital order.
The contribution that mental illness had made to the commission of the offence would be taken into account in sentencing.
Correct.
Now, the problem arises in relation to murder, that there is only one sentence for murder, namely life imprisonment. And so the law has had to invent the concept of diminished responsibility so as to enable a person who kills someone with mental illness contributing to the commission of the offence, to enable them to be dealt with more flexibly than they could be if they were convicted of murder. And so the mental element has to alter the offence of which they are convicted. So instead of being murder, it becomes manslaughter.
Correct.
The basis of conviction.
I'm sorry, my Lord, your voice is going almost completely.
But the basis of the conviction still has to be the existence of responsibility, of criminal responsibility.
That is the criminal concept. And the point with respect, we say that you would be missing, or are missing in this, or implicit in this question, is that it is not incoherent in terms of a tort law analysis to do something other than simply transplant the notion of that type of mens rea, or let's call it, you're calling it criminal responsibility, into the Patel, well, I mean, let's just say we went straight to Patel, into the Patel question, which is balancing everything up. Is it right? I don't know whether you have me on sound.
We have you on sound.
So the whole thrust of our case, my lords, my ladies, on this is that, and the analysis of Dr. Dyson, is that simply because a defence was not available, the whole purpose of Clunas, and we need to get on to Clunas and Gray quite soon, it is that because she could not show that she was McNaughton insane, she loses her tort claim. So the law accepts that there are circumstances where extirpate where illegality will not, the defence will not be enlivened. And what we are saying is it is not inconsistent or incoherent for the civil law, of course, to take into account homicide, Section 2, all of the points that my Lord is making, and of course Mr. Moon makes very clearly, and the Court of Appeal and Mr. Justice Jay made. There is nothing wrong. In fact, it is consistent with the criminal law process to find that there is nothing incoherent in holding a tortfeasor to the consequences of their own tort in circumstances where there is no capacity on behalf of the criminal defendant who has, of course, committed a grave crime. There is a question, I think, from Lady Arden.
Could you say that the coherence is established by recognizing the different policy aims of criminal law and tort law, respectively? One, the criminal law focuses on deterring the behavior of the defendant who might, a person who might commit a crime. The object of tort law is to encourage people to behave properly and avoid claims being made against them.
Yes, that's exactly what we do say, and what we say as I work through the note. And of course, tort law is vindicatory. It has nothing to do with punishment. And that, of course, my Lord Reed, is the complete answer to your question. If you focus in too closely simply on the existence of technical mens rea, then you're led to a position where the law is extraordinarily harsh and extraordinarily disproportionate in cases like this, which, of course, I should say, because floodgates surprisingly does come in later on in the argument. There are very few of these cases, thank the Lord. But when they do come along, they need to be looked at with extreme care in making sure that those those sort of parallel policy aims, the law does not have to be the same. This is not all about sameness, it is about difference. So if that's, I think, Lloyd Jones.
Yes, Mr. Bowen, the Law Commission report to which you refer is, of course, concerned with insanity and automatism. I should say my name appears, but it's largely the work of Professor Ormerod, in fact. Almost entirely the work of Professor Ormerod. But the conclusion of the Law Commission was that there was no serious problem with the law in relation to insanity. We're concerned here with a case of diminished responsibility, where in terms of the criminal law, there is responsibility. It is simply diminished.
Well, of course, I accept that. But the fact that there was no significant problem in terms of insanity meant that even though there were problems, which I think are acknowledged, now we just simply don't have time to look into precisely what they said, what was said in the report. But the fact that there were problems with profound problems with the insanity defence was only not dealt with because it was not a practical problem. The practical problem which concerned the profession, which came up in the consultation process, related to, I think in the main, not being fit to plead, unfitness to plead. So we don't shy away from the fact that criminal responsibility in the technical sense remains, but that is not an answer to our case, which was summed up very succinctly by Lady Arden. Could I move on, because I've got only on page 7. We then at the top, could I just read that in at the top of page 8? We've got A60. We conclude that a person is not to be held criminally responsible for an act or omission where, for reasons beyond his or her control, he or she lacked capacity to control his or her conduct. So you can see from this material that Professor Ormerod felt that there was a real problem with the criminal law, which gives you a conceptual or theoretic answer, at least, to the point that Lord Reed makes effectively against me, which is that there is criminal responsibility, bang, bang, that must be the end of our case. I mean, we say that that would be, that is simply that doesn't even begin to face up to the problem that we say lies at the base of this. So then I come to paragraph 24. We then look at the Patel test, responsibility and the Patel test. Against all that, how does the law decide whether there is coherence? We say that's a battle already fought and lost, or fought and won, depending which side of the argument you're on. The ratio of Patel is summarized at our written case, paragraphs 11 to 13. I won't go into that. Two broad policy reasons. Again, this is paragraph 26. Sorry, I've covered this already. Profit, incoherence. And then we get at 101 the familiar test, prohibition considerations, proportionality. And then the top of the next page, in deciding whether to extinguish a sound cause of action, we look at three questions which are of equal significance. And they are, of course, a seriousness, centrality, intentionality, and the marked disparity in the parties' respective culpability. And then at 120, if we just go to the conclusion, which is at 868. You see there, and I won't read it out there, but you see the essential rationale of the doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. And then the 3 Ps test, as it's often called, is set out. And the point at letter B on 505 is made that various factors are relevant. It's not a free-ranging discretion. It's not decided in an undisciplined way, but it leads to transparency and proportionality and the avoidance of arbitrary decisions. And of course, we say that that's what happens here. If this tort claim is lost as a result of a rigid adherence to the Moniz test in Clunas and Gray, then that is arbitrary, given her lack of personal responsibility, lack of capacity, and the fact that the criminal law decided not to punish. Can I now go into maybe something that I hope will go some way to answering the question on personal responsibility? What do we mean by it? So we're asking the court to really develop a doctrine that the illegality defence doesn't bite where there's no significant responsibility or no significant personal responsibility on behalf of the tort claimant. And what do we mean? How is it assessed? Well, our primary submission is that it's a question of fact. A trial judge would have to make findings both at the threshold stage and then if there was enough there to think that there was enough turpitude, if the defence could survive the structured approach of Patel. Now, 3 points follow. In many cases, this will be straightforward. The face of the conviction and the sentencing will show, in some cases, whether there is personal responsibility or not. It was a presumption in Clunas. We'll see that from, I think, 988 or 998 of Clunas, and an assumption from Lord Hoffman in Gray. He, of course, simply derived the notion of personal responsibility, which, for your note, comes in at paragraph 44 of Gray, and again repeated from memory by Lord Roger at paragraph 69. So they bring in themselves this notion of personal responsibility. Now, in Gray, and we had this, went uphill and down dale with Mr. Justice Jay about precisely what type of case was Clunas, what type of case was Gray, what did the report tell us about where they stood on the Section 2 continuum. And the conclusion was that, well, couldn't really tell without all of the psychiatric evidence. but quite plainly it was a case where there was significant responsibility. The same in cases like Zastany, Hall and Herbert, Winegold, the marijuana case in Australia. All of those cases which analyse extirpi causa are cases which involve claimants who are asking to shift the sanction to a third party in circumstances where they had full responsibility, or if it was impaired in some way, it was some considerable way up the substantial impairment continuum. Now, in our case, the answer has been provided by nobody other than the criminal judge applying criminal law. Clear from the sentence, no section 45A. Clear from the sentencing remarks, no significant personal responsibility.
Section 45A has a different purpose altogether, but that's to do with situations where where the person is currently mentally ill, but it's reasonably foreseeable the person is going to recover their health, and if they've committed a crime with criminal responsibility, it's appropriate that in that event they should be transferred from a hospital to prison to serve the rest of their sentence. That's what Section 45A is.
Well,
follow that in the absence of a Section 45A order, there is no punitive element in the sentence.
Could you bear with me a moment, my Lord? I just flicked on to go back to the statement of, I think Mr.
Moon has his hand up.
Yes, my lord. The reason I had my hand up is I'm really sorry. I still can't hear all that your lordship has said. It didn't perhaps matter, except I did miss the critical part of what your lordship just said. And I would quite like to know what your lordship said just in the last part of the question. Thank you.
Sentencing remarks.
Well, I was putting to Mr. Bowen that the purpose of Section 45A was to enable the court to provide for the transfer of convicted of a criminal offence who is currently mentally ill but may well recover their health, in that event to be transferred to prison to serve their custodial sentence, which was something that previously the courts couldn't do because they could either make a custodial sentence if the person was well, or alternatively, if they were not well, the court had to make a hospital order. And the unsatisfactory consequence was that the person's release, if they recovered their health, could be quite rapid and could be dependent on medical judgment in a situation where the court would otherwise have felt that punishment was, a custodial sentence was appropriate. Yes, Mr. Bowden.
I heard it first time, I didn't hear it second time, but could I ask you in answer to the question, either version 1 or version 2, to look at 56 of the bundle? And could I just caveat this? I am now quoting a first instance judge against the President of the Supreme Court, and I am speaking as a non-criminal practitioner or non-core criminal practitioner. But the complete answer on the face of it to 45A is the penultimate paragraph. I should say that there is no suggestion in your case that you should be seen as bearing a significant degree of responsibility for what you did. Had there been any such suggestion, I would have given serious consideration to making an order under Section 45A of the Mental Health Act 1983. However, on the material and evidence before me, that issue does not arise. Just a couple of quick points. The people who really understand how on the ground this type of sentencing operates, I suspect, are full-time criminal practitioners, full-time criminal sentencing judges. I have taken, and of course, of whom your lordship may well have been before entering an appellate part of your career. I'm afraid I haven't studied your CV sufficiently carefully. I haven't done a criminal jury case since about 1987, so I kind of pass on this one. It may well be a simplistic approach, but what we have done, and we can of course do a bit more work and provide something overnight for you, is we have taken the criminal judge's approach to say that Section 45A, what I've called the hybrid order, would have been exactly what he would have considered had there been a degree of personal responsibility. My Lord Jones.
Mr. Bowen, I think for my part, I'd be grateful for some assistance in relation to this, but my present understanding is that Section 45A does not enable us to draw a bright line to say that there's no Section 45A order and therefore there is no significant responsibility. It's a point you can make that no 45A order. It doesn't follow from that there was no responsibility.
I think subject being told otherwise. Queen and Edwards, 83, page 83 of the bundle. Says Section 45A is appropriate where a penal element is required. Paragraph 12 and 34 of our case. Oh, sorry, paragraph 12 and 34 of Edwards, at which you find at paragraph 12 at EB 1739. So if we go to that. So paragraph 12, I'm very grateful to Ms. Scott for this. I got it, sorry. So the sentence that just over halfway down, this is because. So yeah, I have it. There's a discussion about 37 playing 45A by the look of it. Consideration of a Section 45A order must come before the making of a hospital order. This is because a disposal under 45A includes a penal element, and the court must have sound reasons for departing from the usual course of imposing a sentence with a penal element. Sound reasons may include the nature of the offence and the limited nature of any penal element if imposed, and the fact that the offending was very substantially, albeit not wholly, attributable to the offender's illness. However, the graver the offence and the greater the risk to the public on release, the greater the emphasis the judge must place upon protection and the release regime, and the release regime, of course, is controlled by Section 41, the restriction order. And then, for completeness, if we then look at paragraph 34 at 1742, general principles. Got a long paragraph. Finally, you have a marked up. Yeah, the relevant part. I read this whole paragraph into my submissions, but the relevant part I think is at Roman numeral 2. If so, or take it from 1. The first step is to consider whether a hospital order may be appropriate. If so, the judge should then consider all his sentencing options, including a Section 45A order. In deciding on the most suitable disposal, the judge should remind him or herself of the importance of the penal element in a sentence. To decide whether a penal element to the sentence is necessary, the judge should assess as best he or she can the offender's culpability and the harm caused by the offence. So here what we're seeing is the flexibility of the criminal system to sort of have shoulder movement, for want of a better word. Criminal law itself might be, as I understand it, quite inflexible, but the remedies available are indeed flexible, and that's why I mean we have just taken on board, and this is maybe my Lord Lloyd Jones's point, that 45A is it's good enough, I think, subject to being corrected at lunchtime. It's good enough for us simply to say that it's a major marker, it's a major consideration that this is a case where Mr. Justice Foskett was right in finding that there was no significant responsibility. Otherwise, he would not have used, because he could have protected the public and he could have ensured treatment for her by taking the 45A route. The lack of penal sanction tells you all you know to avoid the inconsistency and incoherence, which is absolutely essential following Hall and Herbert, all of the other important cases, to establish that damage to the integrity of the law. So, going back to my note on significant responsibility, there will be some, so I had my 3 points. What does the judge say? What did the judge do by way of sentence? He or she may or may not have said so in terms. That's our case. So no problem at all with our case. There will be some more borderline cases where the court will have to consider wider evidence before coming to a view. Now, we say that it's not necessary for the court to lay down any kind of gloss or test for first instance judges to follow when assessing the personal responsibility of a claimant, because we can see here, this is the best example. And if it doesn't work in a case like this, it's never going to work. The judge says quite clearly, you are not personally responsible. That is enough. And that, for want of a better word, trumps any residual mens rea that exists as a result, of course, of the Clunis point adopted by Lord Hoffman, that yes, you are very substantially impaired, but you've still got a bit of responsibility. So you've got, I think, Mr. Goodkamp, who is a prolific producer of academic articles in this area, but ironically is on the other side, but a lot of his points, in fact, score home right big own goals for Mr. Moon, we say, because Mr. Goodkamp himself, I think in a long, hard look at Thames Trains, talks about pronouncement consistency. This is in the context of absolutely eviscerating Lord Hoffman's wide rule and saying it serves no purpose and it just shouldn't be part of the law. He says you've got pronouncement consistency and you've got some other kind of consistency. I think it's goal consistency. The goal consistency reflects what the intervention from my lady, Lady Arden, about what the criminal law is trying to do as opposed to what the tort law is trying to do. So if one were to give in to, if I may say so, with all the respect I am able to sum it up, really conservative attitudes to this with a small c, because there is some residual mens rea, that means our argument must be hopeless. That is, I think, in our respectful submission, to seriously downgrade what we're saying in terms of personal responsibility. And there's a lot of academic support for what we are saying. So if you're not with us on that, we've got a second string to our bow. And we say, in the alternative, and if the court consider a test is required, we submit that an appropriate legal test can be formulated as follows. We start by asking what it is that makes a person responsible for a criminal offence. And I've looked at that with some detail, expressed by the Law Commission as the capacity to conform one's behaviour to the standards the law imposes. This, we say, if your ladyship say, we want you to provide a test, that is our test. This, we submit, is therefore the appropriate test. The Law Commission's proposal was in relation to criminal offences, but in principle, the lack of personal responsibility would apply to that person's capacity to conform their behaviour to meet the demands imposed by any given law, including strict liability and regulatory offences. Now, there's an alternative. An alternative would be that found in the Mental Capacity Act. However, this predominantly is a forward thinking or has a forward focus, so it doesn't probably translate terribly well into crime and tort. If it did apply, it would ask if the person had the ability to understand, retain, use and weigh all relevant information in relation to the offence. My Lord?
Could you tell me where you are in your note, Mr. Bone? I'm sorry.
I'm off my note.
Off note. Right.
It's gone off piste.
Thank you.
I've gone off piste, but it's beautifully word processed. It was in for your note. We will send it to you. I'm entirely reliant on my extremely diligent juniors for this. It's a rider A between paragraph 30 and paragraph 31.
Thank you.
This, we say, is a comprehensive answer to the googly served on me by the Lord President. Where do I go then? So, significant personal responsibility should not equal McNaughton. That's the next bit. 3 reasons, and I think I've probably covered some of these. That test is much criticised, as we have highlighted in our written case. It is not recognised as a good test for a mental capacity defence. It has been saved only from immediate reform because it is so bad that few defendants lead evidence to try to obtain it, since they cannot plead it directly. And of course, not that many people want to be declared criminally insane by the state. So that's the first point. The second point is that, and this is I think a very fundamental part of the argument. McNaughton addresses only one reason in crime for the absence of capacity. It ignores the following, 2 of which apply in our case. Unfitness to plead, that didn't apply in our case, I think, whereby no criminal trial can take place until the defendant is no longer under a disability. That is to say, under any disability such that apart from this act, it would constitute a bar to his being tried. And that's a reference to the Criminal Procedure Insanity Act 1964, Section 4. So a trial can't take place on the grounds of absence of capacity. So that's McNaughton plus 1. McNaughton plus 2 is infancy. Criminal age of responsibility, I believe, is 10 years old. In tort law, it doesn't exist. It does not have this to deny what we might call moral agency. And there's a lot of tort law, I don't have it at my fingertips, but about where I think parents are responsible in many ways for the torts and unlawful or tortious acts of their children. The third, so McNaughton plus 3, is automatism, the lack of physical control of the body for whatever reason. It can come from insanity or from another cause. So you have insane and non-insane automatism. The famous case that we all learned at university and law school about, can't remember the name of the case, but chap's driving along and a swarm of bees come into his car. He's not criminally responsible. You then have the fourth alternative, the partial defence of diminished responsibility under Section 2 of the Homicide Act. That's our case. And then sentencing through a discharge, Section 37 or 41, whereby the person is admitted to such hospital as may be specified. That is in very similar terms to the 1964 Act, and also includes sentencing remarks from the judge describing the status of the defendant. So McNaughton is absolutely not the end of the story here in terms of capacity in the criminal law. And that's why it's to take far, far too narrow a focus. If one is concerned about the residual level of responsibility, and because you're not McNaughton and you're on the continuum, but not very far up it, that still then is enough of an inconsistency and an incoherence to mean that the tortfeasor is to be excused from the foreseeable consequences of their acts and negligent acts and negligent omissions. So then finally, because of all the reasons we've developed in our case, and which I do hope to come to, although I can see it's 17 minutes past 12 and we haven't had a break. Finally, it's not compliant with the Tell and Mirza. Do you want me to stop there or just finish this section?
Just finish the section, Mr. Bowden.
I'll finish it. Right, okay. A trial judge faced with a claim of illegality would have to determine the 3P test: prohibition, policy, and proportionality. And in doing that, the trial judge would simply ask, did the claimant lack capacity to conform their behaviour to the demands imposed by the criminal law? If the answer is yes, and there's no significant responsibility, illegality falls away, has no role to play, threshold not met. In effect, the criminal court has already made clear there's no breach of the prohibition, so you fail at stage 1 of Patel, and would give a reason for a civil court not to give a remedy to the claimant for losses caused by the defendant. In effect, these reasons find the absence of personal responsibility and have the same effect for tort law's purposes as a finding of not guilty. So no responsibility is the simple point. So while the test might appear potentially difficult, a criminal judge might already have, well, I've covered this. Sorry, this is repetition. No punishment, no personal responsibility, section 37, not 45A. If there is no such order or determination from the criminal judge, claimant would be able to lead evidence in the civil claim to answer the question, did the claimant lack significant capacity to conform their behaviour to the demands imposed by the criminal law? Now that brings in, we haven't looked into it, I think, in any great detail, if at all, in the case, but that is, we're now getting into the area covered by section 11 of the Civil Evidence Act, and the question of personal responsibility through a civil claim, looking at, in a civil claim, what actually was going on in the criminal case. And that isn't a collateral attack, it's not an abusive process. There is an argument which we can't even begin to get into here, which is the extent to which section 11 operates. Section 11, for your note, you will see at page 937 of the bundle. We just have a I don't have time to go to section 11. I won't take you to section 11. There's also, in due course, I'll give you the reference. There's also a long article published again by Dr. Dyson some time ago about how section 11 works in precisely these circumstances. So we say that the civil court, the short point is the civil court could very easily look into the question of personal responsibility without in any way abusively treading on the toes of the criminal court. So that is the answer that we had to my Lord's question on how you approach the concept. When would you like us to come back?
Well, thank you very much, Mr. Bowen. I think we have an adjournment just now of 5 minutes, and we'll see if we can do something to improve the technical connections during that time.
Can you hear me, my Lord?
Yes.
Good. Thank you. So I'm moving on now from significant responsibility, and I'm at paragraph 31 of the note. I'm going to have to accelerate and maybe really summarize some of these chunks. Paragraph 31 is a point there, self-explanatory. Inconsistency that lies beneath the defence is to be sparingly employed. You have the references. I won't turn those up. That takes me to my next main section, which is, should the Patel test apply widely? We have quite a lot on this, but I don't think I'm going to have the time to go through it if I'm going to do Clunas and Gray properly. So I read all of this into my submission. What we are effectively saying is that the illegality defence the Patel approach to the defence is of wide application. We don't need to go as far as saying it goes across the whole of the civil law system. For our purposes, it's sufficient to say that it covers the law of tort. And we pray in aid of that the intention of the Supreme Court itself. That's 37.1. That's what the academics, particularly Professor Burrows in his articles there at the foot of page 10 of the note, has said. It wipes the slate clean. I was going to turn up 2589, so if you could just put a red mark against 2589 and 2591. The quotes are there on the note. He feels that it's applicable across the entire terrain of civil law. The majority of the judiciary have treated the reach of Patel as a wide approach. You've got all that in our case. You'll be familiar probably with most of these: Singularis, Ocadina, certainly XX against Whittington Hospital, Stoffel, McHugh, and one of the Shenning cases. And a good example of using the threshold is Lady Hale. That's at 38C. Again, I won't turn it up, but there was a discussion about surrogacy, whether criminal offences here as opposed to in somewhere California, I think. And they just felt, sorry, 38D, the appeal in the Supreme Court was against the application of the test. And the court really made pretty short work of that and said, well, you just don't go there at all. There is not sufficient turpitude. Now, of course, I know surrogacy playing the savage, psychotic killing of a human being is maybe somebody will say, well, that's apples and pears. But the principle is the same. There is no sufficient turpitude for a whole host of different reasons. So 39, the extent of the Patel test into this area would bring certainty and clarity to the law. There are then various references to Patel itself, which we say, in fact, 869 is Lord Kerr making the certainty point. The alternative, we say, is not very satisfying at all, because there will again be a similar mismatch and mess that we've had before in this area. One of Lord Sumption has given lots of memorable phrases, albeit he was on the losing side ultimately in terms of rules versus range of factors. But he says it's all very well, but we don't want to replace one mess with another. And he felt that was the problem with the range of factors, hence the profound disagreement with Lord Toulson and the majority. But here we have a similar problem in that if it's not Patel, but it's Gray or Gray plus or Gray adapted in some way, people will not know where they stand. In manslaughter cases, it could be a mixture. This is little I on page 12. It could be Gray narrow, Gray wide. What about reliance? Other tort claims, Patel post singularis. In unlawful discrimination claims, Huanga, it could be just more of an emphasis on policy. In the assault cases, you could have a different test again. Inextricable link, for instance, is one that was not, although Lord Hoffman in Gray did not find that type of metaphor, I think he said, helpful. He certainly did not extinguish it as a principle. So in short, we won't know where we are. The respondent effectively says, well, the Patel test should apply in tort, but only apply in a novel case. We do not accept that. But if your lordships, if your ladyships were attracted by that, we would say, well, this is a novel case. It's a novel case because there's no binding authority. The reason there's no binding authority is because Gray deals with cases of significant responsibility, and this is a case of no significant personal responsibility. That's paragraph 40 of the note. And it's a case we say that won't obviously, a novel case, or alternatively, a case that would not withstand the Patel analysis that's the case we're facing. So we say that is not an answer, not to our point, but to Professor Burrows' interpretation, the width of Patel. Now, underlying Mr. Moon's point about novelness is a comparison with Caparo and the well-known error that we're now also familiar with as a result of the Robinson litigation. Caparo, the court will be probably familiar, I won't turn it up, but Robinson 1870 of the electronic bundle explains now, some people call it the new approach, but Lord Reed was specifically saying Robinson decides nothing new. It restates what we always should have known, and that is that Caparo itself did not seek to provide any kind of unitary answer to when a duty of care should or should not be imposed. The fair, just and reasonable approach, which in the Court of Appeal was said to apply to every negligence case, was a sort of malformation of the law, and something that should never have happened had anybody had the, it's an awful thing to say, but had the judiciary and the profession actually read Caparo properly and honoured Caparo, we would never have gotten to the mess that we did, which was finally sorted out by Patel. By Robinson. So the comparison between Patel and Caparo just doesn't work. What they're effectively trying to say is the law repudiates now any idea that there is a single test which can be applied in all cases. Now, it may or may not be that some people say Patel is somehow against the run of play, because we've moved from, in the development of the law of tort generally, we've moved from policy. So this is the theme that we have run through in the cases of Michael and Robinson, where in Michael I submitted, and again in Robinson, that policy, that the policy, constituent parts of the policy underpinning a duty of care are now no longer valid, and therefore you should get rid of the Hill immunity. I mean, that was the base of it. The state should no longer be responsible, should no longer be immune for certain acts. And the approach of the court is that, well, you go back to the orthodox approach, Gorringe, etc. I mean, I'm not going to go off-piste on this. The point is that principle and structure comes back in, where before we had a bit of a free-for-all with policy, fair, just and reasonable. There's a Lord Bingham has said in one case about you can't have the law being a mass of single instances. And that's what Patel has sought to avoid. Patel provides structure. It provides a reasoning process which is transparent. Everybody knows where they are. So what Mr. Moon is asking you to do, for obvious reasons, because he is so desperately keen on holding on to this harsh, inflexible reliance on that little bit of mens rea that is left before you become properly insane. Now, that's why he says go back to Gray, don't look at Patel. They're terrified of Patel because once the facts of this case are inputted into Patel, we say there's just no contest. It's quite plain that the incoherence is in denying the tort claim, not in allowing it. So we say with respect, that doesn't help. The whole point of Patel, this is 41R, the whole point of Patel was to sort the mess out, wipe the slate clean. That's Professor Burrows. I've probably covered the rest now of that, and that takes me on, thank heaven, to the main point in the case, which is, of course, Clunas and Gray. No, one point. Paragraph 47, top of 14 of the note. And again, we say this with all due respect to Mr. Moon and his team, but we find it, again, I'm afraid we don't hold back. We describe it as outlandish. There is nothing at all in the rather outlandish point made by the respondents in that they've collected 65 cases in a table at the back of their written case that were decided before, or 65 in total, 45 before Gray. If you are brave enough, they say, it's a sort of don't scare the horses approach. Do not go this far, they say, because if you do, you are going to have to, or somebody else is going to have to, look back at the entrails of at least 44 cases and conceivably 65. Well, that, with respect, is a complete misunderstanding of Robinson, and simply will not wash. There are Robinson itself. The profound point about Robinson was, should the police be responsible, should the police be immune for all of their acts and all of their omissions in connection with the investigation and suppression of crime? A massively wide area which took in any number of activities by the police. That has been brought home to where it should always have been, Lord Keith in Hill, that it only applied to a failure to control third-party damage, third-party killings. That's where the law is now. However, the analysis in Robinson brings into serious question many of the old cases, El Ghazouli Daff, Ansell and McDermott, many others. I haven't referred to any of this in the case, but to those who practice in this area, this is all well known. In that case, it was never said by Mr. Johnson or in that case that it was necessary. The one reason you shouldn't go there is because there's a table of 304 cases which will have to be looked at again. With respect, that submission simply does not stack up. And we say that you might get some help from paragraph 100 of the Joggi or the Jogi case, EB 1786. If you just have a quick look at that one, you can see, although it's all about criminal convictions and appeals, you can see at paragraph 100, and I quote parts of it in the note, the effect of putting the law right is not to render invalid all convictions which were arrived at over many years by faithfully applying the law. The court observed that, I've rather put this together, I think. The court observed that alarming consequences would follow from permitting the general reopening of old cases on the ground that a decision of a court of authority had removed a widely held misconception as to the prior state of the law on which the conviction which it was sought to appeal had been based. No doubt otherwise everyone convicted of dangerous driving over a period of several years would have advanced the same application. So a change in the law will not mean an automatic re-examination of what was gone before. That's all I've got to say on the width of hell. And that brings me on then to Clunis. The approach of a lot of this is in the case, so I hope go through this reasonably quickly. It's addressed in the case at EB 70. Don't turn that up. Argued in Clunis, this is top of page 15 of the note, that the illegality defence should apply to those whose moral blameworthiness or responsibility was diminished by reason of mental disorder. Then there was a submission made by Mr. Irwin, as he then was, which is far wider than we make, which is that in any case of manslaughter by reason of diminished responsibility, the maxim shouldn't apply. We're far more nuanced than that, and we talk purely about personal responsibility. Could you turn up 988 G2H, which you see at 698? Can you still hear me, my lord?
Yes, yes, thank you.
So, 698, you see the 988 G2H. These principles seem to us to be relevant to Mr. Irwin's next submission, that not all criminal or illegal acts will prevent the court from entertaining a plaintiff's claim. Pertinently, he said that there are today many summary offences which are not sufficiently serious to warrant the invocation of the maxim. The offence of manslaughter is an offence which varies greatly in its moral blameworthiness. especially if the manslaughter is by reason of diminished responsibility. He urged the court to say that where the degree of responsibility was diminished by reason of mental disorder, the court should not apply the maxim. He prayed in aid this in regard to a test which this court, he then refers to the public conscience test. And then the answer to the Court of Appeal's answer is an F. Consequently, though responsibility for the killing of Mr. Zito is diminished, he must be taken to have known what he was doing and that it was wrong. So that's McNaughton. A plea of diminished responsibility accepts that the accused's mental responsibility is substantially impaired, but it does not remove liability for his criminal act. So those are the main parts of Clunis. If we then also look at 9, give me a minute. No, that he must be taken to have known. Those are the words I'm emphasizing. That's the presumption. Only removed, paragraph 58 of the note, only removed if McNaughton is satisfied. And now this has, of course, been given the blessing of the court in grey. It doesn't matter if the offender was on the responsibility continuum. Don't turn it up, but you see there the reference to the monist point of paragraph 28 of the judgment at first instance. Passage from Beldam, from Lord Justice Beldam's judgment treats the question as being monist, not as one capable of differential factual evaluation, at least for the purposes of the ascription of civil liability. And then the court concluded at EB 184, this is again a reference to first instance, that the monist ratio was approved in grey. And then paragraph 46 to 47, again at first instance, then at the Court of Appeal stage, explained that the reasoning in Clunis would provide a defence to all of the defendants' heads of loss, appellants' heads of loss. But in our view, it was only binding authority in relation to the loss of liberty claim, as that was the only claim being made in the Clunis case. And then at paragraph 51, the Court of Appeal held that none of the speeches in grey suggested that Clunis had been wrongly decided. So then we come on to our submissions as to why the Clunis test is inconsistent with the test in Patel. You've got written submissions at paragraph 14 and 15 and paragraph 35. And a lot of this I've probably already covered. Civil law test deciding what will or will not bring the law into dispute based upon McNaughton is simply too inflexible. It has no, it does not have the ability to take into account what the Patel test takes into account. We see then, I've already referred to them at paragraph 65, the question about purpose of the prohibition, countervailing policies and proportionality. It's a presumption, top of page 17, it's a presumption that bites irrespective of where you are on the continuum, made that point. And unlike Commonwealth systems, as illustrated in some particularly of the American cases, but we also see it in the New Zealand, the Canadian and the Australian cases, is whether or not they're talking about the insanity defense or what they sometimes call guilty but mentally ill. We say, I'm afraid I'm not going to have the references, but I'm not going to have time to take you to the cases, apart from maybe one or two references. The controlling concept in their analysis is personal responsibility. That's the theme that runs through. The reason that the insanity defense is an exception to the imposition of the illegality defense is because there's no personal responsibility. But why limit it simply to, in some jurisdictions, a very harsh approach, the law of England and Wales? As far as we can tell, the law in Australia appears to be the same, but the law in, I mean, I won't speculate because we don't we haven't been able to work out precisely how insanity defences vary and differ between different jurisdictions. No room in the harsh clueness test, I'm reading now from Roman 3, to consider stage 2 or stage 3. And I bring to the battlefield at this stage Lord Sumption, who said in a, and can you turn this up please, 2938. This was in a lecture that he gave to the Chancery Bar Association in 2012. And we see similar comments in Apotex itself, 2938. 2938. Although he's talking about illegality here rather than specifically about McNaughton, or about Gray rather. At the same time, there are some distinctions which respond to most people's moral instincts, but which the law does not make. It provides no satisfactory basis for distinguishing between different degrees of turpitude or between different degrees of culpability. It is wholly indifferent to the proportionality of the illegal behaviour and the potentially drastic consequences of being denied relief. And you have that reference at Roman 3. So to consider whether the law is likely to be brought into disrepute by allowing a tort claim in these submissions, it's necessary, we say plainly, to look at the significant responsibility for the commission of the offence itself. And that is plainly, in order to make that submission good, I look at, then we go on to look at some of the comparative material. 68, then on to 69. Responding to what Mr. Moon would say is, well, the Australian cases and the American cases that talk about responsibility being the controlling theme, an answer to that is that, well, they were insanity cases, but we say with respect that is not the answer. The whole point is that the requirement of the rigour to meet the test cuts out deserving tort claimants who are not significantly responsible for their conduct, despite the fact they are not having a McNaughton offence. And there I said at the beginning of my submissions, just going back to the facts, that the simple fact that she was unable to resist, had no common ground, she had no rationality, no capacity, because she knew that what she was doing was wrong, and because she understood that it was her mother, not the log or not the cake, but nonetheless was on any view not significantly responsible because of the bright line that we have as a result of the McNaughton test. Totally disproportionately, in fact, I would go as far as saying, with respect, arbitrarily cuts her out completely from any form of recovery. And the approach that we take to the law, not only is it supported in the comparative materials, it is an approach which has to be, if Patel applies, unless you retain Gray in aspic, which is what this amounts to, you have to go to Patel. Once we go to Patel, Mr. Moon's points, and with respect, Lord Justice Beldam and the approach of Lord Hoffman, paragraph 41 of Gray, which we'll see in a minute, that all falls away. You've got the references to Rimmert and Ellis. There's another case called Borowski, or no, Burashevitz against Kurtz. They're all noted there. and I won't, I think, take you to them. The Rimmett quote you see at 78, I think, and 79. Just make sure I got the right one. Just bear with me a minute. Yeah, Rimmett at 2550. That's quoted at paragraph 79. In this case, the general description of the defence in the relevant American law was described as follows. The public policy bar should not operate to preclude an action based upon or involving an ostensibly criminal act to the extent that the plaintiff was not in fact responsible for the act. A prohibition against imposing liability for one's own criminal acts to another through a civil action is simply not justified when a plaintiff is not responsible for the act or for the act or acts in question. And what happened there was the lower courts in Indiana. In Indiana, even if you were insane, the insanity defence did not enliven the illegality defence. And what the appeal courts said were, well, the law has got to recognise responsibility, so she's got to be able to go back to be able to prove that she wasn't responsible. Paragraph 82, we pick up a similar position in Ellis. The board raised the defence of illegality and the judge held that this was not a reason to deny the claim, as the claimant had been found not guilty by reason of insanity and thus had been acquitted of criminal responsibility. So all these cases confirm the Clunas approach in terms of insanity. So that part of insanity, of course, we wouldn't say for a minute that that exception is not justified. It's just much too small. It's got to be expanded, and not expanded by any great degree, but to take in cases like this. And in so doing, you are not allowing in a great flood of undeserving claims. You're making sure that the law reflects a set of a type of case. Recovery does not equal incoherence. No left hand, no right hand problem, and there is no insult to the integrity of the law. Very much the same point is then made throughout page 21. There's a reference then also to Hunter and Presland, which is another well-known case. The 89, the respondents rely on Presland at paragraph 114 to 115 of their case to demonstrate that our suggested approach is not an accurate reflection of the foreign jurisprudence, and that the overwhelming weight of authority elsewhere in the Commonwealth and in the common law world generally supports the application of the doctrine of equality in this case. Well, we're not going on a sort of tour de horizon, I think, which is what Lord Steyn called it in one of the other cases, where there was an enormous research into what was going on in the rest of the world. You can see here, just in the smorgasbord that we have put before you, that responsibility as a controlling consideration is one of the golden threads that runs through this type of case. Just to put right one, we say, error on Presland, which is made both by my learned friend and with respect, as we'll see in a minute, Lord Hoffman, is in the Hunter case. That is cited as an example where the extirpi causa illegality defence was enlivened to defeat the claim. That is not correct. And we get that. The part of Presland that's relied on by my learned friend is at paragraph, quoted at paragraph 91. I won't quote it. The bit that you need to look at is 92A. I will just go through that quickly. Just to explain, there were three judges, all beginning with S: Santauer, Spiegelman, and Scheller. And Spiegelman dissented on the basis that he felt there should be no duty of care against the statutory background, and that was all about whether or not there was a duty to detain. So that's the very familiar question about whether you're imposing a common law duty against statutory background. Santow, 92A, Santow felt that the residual unlawfulness inherent in the act of killing could be taken into account at the liability stage. I agree with the observations of both Spiegelman and Scheller insofar as they deny application of the ex turpi maxim as a defence to civil action, or as automatically breaking the chain of causation where there is no crime, nor any rational and voluntary act, nor moral culpability by reason of his insanity at the time he killed Miss Laws. That said, I consider that the residual unlawfulness of the respondent's act of homicide is a factor that may properly be taken into account when considering the normative aspects of causation. And it's to that aspect that I now turn. And then I'll read in Spiegelman at paragraph 78, who says something really very similar. So whilst it's correct that that was an insanity case, ex turpi causa didn't stop it. It was stopped at the stage that Mr. Moon conceded, or Mr. Moon's clients rather, conceded his case, which is that there was a duty of care. There was both a statutory duty under 17AE, or whatever the subsection is in the Mental Health Act, to bring her back from the community treatment order. But there was also overlaying that a very important obligation in the law of tort to make sure that that statutory process was carried out with due care, with reasonable care. It wasn't. They've accepted foreseeability. They haven't said that the killing eviscerates the original negligence. None of that has been argued. It was argued in other cases. Conceivably, it could have been argued here, but it wasn't. And we say, of course, even if it was, then we would have survived. We would have had a duty of care, but that's another battle. It's now 1 minute past 1, my lord, and I was going to refer to Zastany at 93. I haven't got as far as I hoped. I'll cover Gray when I come back in the hour that I've got left, and I'm not going to have time to cover an awful lot of the material about what happens if Patel applies. But of course, that may or may not matter if you decide either you can't look at Patel now until you've adjudicated on the test, which does seem to us to be quite a problem, or you remit because we need more evidence. The rest of the next 30 or 40 pages of this note go insofar as you don't want to hear that aspect of the case now. It's not been argued yet in front of either Mr. Justice Jay or the Court of Appeal, and we understand entirely how finality would be a wonderful thing, but I'm just not going to have time to go there.
Are you going to deal at all with the possible role of contributory negligence?
I'll think about that one over lunch. I mean, I think yeah. Well, just very briefly, yes is the answer. Just paragraph 49 of Gray in the Court of Appeal. There's nothing wrong with tort rules. There's nothing wrong with contributory negligence. Do everything that illegality can do. I think that's the answer.
Yes, I'm just thinking through if one were to accept that responsibility isn't an all or nothing factor, then you might have two causes contributing to the same result here.
Well, you have. That's exactly what we'll see from Lord Sumption when he talks about this in Apotex.
Very well. Shall we adjourn now? We adjourn now until 2 o'clock.
Thank you very much.
Thank you.